IR. She's wearing her IR hat today, not her Silver Creek broker hat, but she's amazing. Krista Deacon. And we have David Hensley from the Idaho Realtors, and he's helped with the forms and been kind of at all of the meetings that we've had nationally and locally. I know I'm missing Tim. Oh, Michelle, Kit, the other redhead, sorry. I looked right at you and I just walked right by. So we have Kit Fitzgerald and she's with IMLS. So a lot of the changes that we're gonna see with the NAR have to do with the MLS and what we can do and what we can't do in the MLS. So we're gonna have all of those folks come up here and sit down and we'll ask them a couple of questions. I did wanna, real quick while they're getting seated, we have our RPAC pin, and it would be remiss of me if not to mention something about RPAC. So recently we all went to Washington, D.C. for our mid-year meetings, and we meet with the legislators. And one of the things with this particular case that came up was VA loans, right? Where VA loans, buyers can't pay compensation. And so if the buyer was to have to pay compensation, it was going to negatively impact those VA buyers. And I can tell you that we met with all 535 representatives, and the VA changed their policy about 2 weeks later. So there's been some, so if you pay the $30 on your fees, or you're a major investor, that $30 helped with our industry. And that's just one of the things that they've done. David helped us get Essential in 2020 with that RPAC money. So there are lots of things that RPAC does for us. And don't forget that we have advocacy as one of our big talking points. I would like to start with Michelle, because when this all came out, everybody was all wound up about buyer rep, buyer rep, buyer rep. We have to have buyer rep. We have to, and a lot of states changed to make buyer rep a legal requirement, that you had to legally get into a buyer representation agreement. And I think everybody was really confused that we had to get into a buyer representation agreement. And it is not so. So I'm going to let Michelle tell us how it affects us legally, and then we'll have David and Krista talk about what we're doing to address that.
Thank you, Elizabeth. Well, if you listened to Tim's presentation, he said everything I need to say. So, so really, this settlement is not. Does not change what we do with real estate law in Idaho. We did, like Elizabeth said, at first we started looking at, do we need to require buyer representation agreements? But there is some terminology that I think is getting confused in this discussion. The buyer representation agreements, whether you are a customer or a client, does not change in this. We do not see any statute change coming forward at this time. We will look, of course, we always look at our statutes and see if we're in line with what the industry is doing. But at this point, agency is still a completely separate thing than what is going on in the settlement. And as you guys know, not everyone are realtors. So the settlement doesn't apply to some of our non-realtor licensees. However, in Idaho, we're a little bit different. 92 to 94% of my licensed real estate agents are realtors. So essentially, we are serving the same people. So most of my licensees are going to be held to the terms of this settlement, but under a license law, we are not.
And you will know what color my new license law book is first.
Yeah, I think we're going to get one, hopefully.
Yay, I think so.
Woo-hoo! All right, I'm going to let David talk about what we're doing at Idaho Realtors to address the case and what we have to do.
Well, how many hours do you have? Well, I would be remiss if I didn't recognize the Idaho Realtors Forum Committee members who are in the room today, including the chair, Krista Deacon. So if you'd stand, please, and be recognized. March 15th. It was a Friday. You probably remember where you were. That's the day NAR announced it had reached a settlement in the Sitzer-Burnett case. That's less than 3 months ago. Herculean effort by the Forums Committee, the Executive Committee of the Idaho Realtors to get you to a place now where complying with the terms of the settlement are going to be as easy as using Idaho Realtor forms. On the compliance side and on the enforcement side, we're going to hear from Kit what that's going to look like in terms of MLS and the changes that you're going to have there. But unfortunately, Kit or Idaho Realtors, we didn't have a choice. We were not parties to the settlement, but we're asked to help you navigate the terms of the settlement. And specifically, how we're going to do that is through forms at the state level. I want to share this time with Krista in terms of talking about what the committee's come up with, but I want to tell you, how many of you are worried about the provision of the settlement that says you have to have a written agreement with a buyer prior to touring a home? Show of hands. Are you worried about that? Well, I want to show you something. Here's the new agreement. Okay. This is not final because I'm going to talk about our process in a second, but the committee has worked hard to get us to a place where we have the new RE5. And it is titled Prior to Showing Agreement. And it is less than a page. And I want to tell you, this is not a representation agreement. This is not a compensation agreement. In terms of the spectrum, I want you to think about it this way. Here's the blue brochure. Okay. Here's the rep agreement. You're here. You're closer to this based on this form. And this form will help you comply with the term, the provision of the settlement that requires you to have something with the buyer prior to them touring a home. Now, you're welcome. And the final thought on just this form, we heard from you. We heard from you, the brokers, and from you, the members, who talked to us about how delicate those conversations are with people who call you and say, hey, I just want to see 123 Main Street. And now you have to show up, and pursuant to the settlement, you're going to have to share this with them. But this is going to give you a tool to help you in that conversation because, again, it's not establishing a formal relationship as you would under a rep agreement. But if you can, great. It's not a compensation agreement. It's less than that. But if you can do that, great. This is going to help you comply with the settlement. So in addition to that, the Forums Committee has been working on a slew of changes to our existing forms. And I think they can best be summarized by saying in the rep agreement and the compensation agreement, we've added language that commissions are negotiable and not set by law, as required by the settlement. And we've added other components that are required under the terms of the settlement that you're not going to have to worry about. You're not going to have to worry about, hey, am I complying with that provision? That, I'm not going to receive any compensation in excess of any of the sources identified in this agreement. No, that's in there. We've taken the heavy lift out of that for you. So I would submit to you, and Krista can talk about some of the other changes. If you use our forms, you're going to be complying with the settlement. So that's the good news. Krista, what would you add?
It's all going to be okay, you guys. I know everybody's been freaking out and stressed about it. You don't need to, okay? This one-page document really clears up the fact that this covers the written agreement. And a reminder, it's not a buyer's rep agreement. And I think that's the misconception that everybody had from the beginning, and Michelle reiterated that as well. A buyer rep agreement is not required. We're not forcing consumers to work with us in a client relationship. And there's some consumers out there we don't have to work with in that kind of relationship, okay? So now we have choices, they have choices, we're all good. This document, when you guys look at it, which will be released early August, is the time frame right now that IR is working with the forms programming. It's more of a, well, it starts with I promise. So the agent's going to promise to the consumer that I'm going to show you this house, but I'm also going to treat you ethically, professionally, and if, big if, we want to take our relationship to the next level, then we'll have another conversation. Whether that's remain a consumer, or, remain a customer or become a client, then we have those conversations about what those fee for services look like. So it's okay, we're all good. Do you want us to just jump into the other forms?
Sure.
Or,
Yeah.
okay, I didn't think we were gonna totally leave with this, but I know this is everybody's, the burning question, is what's this gonna look like? We've got changes to the representation agreements, again, putting that language in there, so you guys are totally fine with that, you don't have to worry about it. There is also a paragraph going into all of our purchase and sale agreements that talks about compensation. Everybody's holding. Are we allowed to do that?
Yes.
We are allowed to do that. So there is Code of Ethics article
1660.
Thank you. 1616, 17 is the arbitration. So 1616 that says, that alludes to the fact that we're not allowed to talk about compensation in the offers. But we are. We're just not allowed to hold offers from submitting them to the sellers while waiting to try to figure out what that compensation looks like, okay? So there's a paragraph in our offers. This goes completely against what I've been practicing all these years and training, my agents, but it's okay. So don't stress about that either. There are 4 tick boxes that pretty much say compensation is a part of this offer. Compensation's been previously determined with, a comp agreement with the seller, or it's been previously determined with a broker agreement, a co-op agreement. And then lines in there too that the buyer is saying, hey, seller, I need you to pay for my agent X% or X dollar. Okay, we tried to make it super simple and super transparent. So how does the listing broker share with the selling broker what that co-op looks like if one exists? We have a form for that.
RE16B.
It's the RE16B.
New form.
A 1-page form, okay, trying to keep it simple for everybody. Basically, this is the listing agent / broker filling it out based on what's on their seller rep agreement of what's being offered. Okay, this cannot go in Docs tab in MLS. It can't be anywhere in the MLS. Or you'll be hearing from Kid. Okay, but this can be shared with the selling broker. So the buyer's agent's gonna call the listing agent and say, is the seller offering anything? And we want you guys to tell your people to call them back, please. Okay, they need to know that information. And so this is this takes place of the field in MLS that's gonna go away, essentially. You don't have to use this, it's optional, but it's a tool, the resource.
Yeah, and to that point, we're encouraging brokers to look at how you want to communicate offers of compensation to potential buyer reps. Through your websites, okay. Through this form, okay. Maybe through a new form, okay. We're going to try to provide you with multiple tools to make that communication as easy as possible between brokers and members so that that can be not only clearly communicated, but remember where that's going to start. It's going to start in the RE16 because if you're the listing agent, you've already predetermined with your seller what you're going to be offering in terms of compensation to any buyer rep. That's a provision of the settlement and a requirement as we move forward. Good news is the RE16 takes care of you. We had a question.
David, Krista, both of you, have these forms been submitted to NAR and blessed by them or told in any way legally that they're legally sound and that we're gonna be okay and we're not reading it from the top?
So the answer is, have they been submitted to NAR? No, because NAR is not going to give us an answer.
Okay.
NAR is not going to sign off on the legality of these because some of the legality stems from the state law, and they're also not going to give us an official opinion on the whether they comply with the terms of the settlement agreement. Now, we're reaching out to NAR. We're asking them questions about specific provisions within there or specific terms. We've received some feedback, but it's primarily been in the form of, hey, here's what other states are doing. So I don't think NAR is going to sign off on forms. They've never signed off on NAR forms in the past that I'm aware of. I think they're providing guidance to MLSs. I think they're providing guidance to state associations and others who have forms. And they're doing a good job of trying to make that guidance available and understandable to us. I mean, they put out a whole series of responses to questions about this form in particular. It was very helpful to us as we went down the path of creating.
We don't specifically commit them to NAR for their blessing.
No, there's no approval process through NAR. No. We had another question over here.
Say that we will be emailing over 16B to the buyer's agent if they request it. We're physically presenting it to them.
So here's the interesting thing, and maybe before we get to answer your question, let us explain our process. Because you've heard about all these potential edits to existing forms, and you've heard about our new forms. Well, what we want to share with you is how IR is going to roll these out. IR is right now in the process of finalizing the forms with the committee. Again, I can't tell you how much work they've put into this. Once we get the final approval from the committee that the edits we've made are consistent with the discussions we had, then IR plans on going to the brokers and MLSs first to explain the edits and updates to our forms. We're going to spend a large part of June doing that outreach. We're going to spend most of July following up on that outreach and then working with members to explain the changes to them after first, again, explaining it to the brokers and to the MLSs and getting feedback from the brokers and the MLSs. I have every confidence that the Forms Committee has created great edits and new forms. We're going to appreciate insight and follow-up from brokers and from MLSs as to maybe some tweaks, but down the road, our hope is to, by August 17th, have multiple videos, multiple webinars, multiple in-person opportunities to interact with the entire membership about these form changes. Now, in addition to that, or I should say parallel to that, we have to work with our forms providers, Form Simplicity and Transaction Desk, because as you can imagine, there are hundreds of entities, whether that's state associations, MLSs, brokerages, who are now asking them to program changes to forms. So we're working with our forms providers for the programming to make sure that these forms are available to you early August and a rollout so prior to the deadline, so that again, people will have access to them. Hopefully they will not be surprised by what's in them because they will have attended numerous or multiple opportunities to talk with us. So your specific question, no, I forgot it. So the practice changes around the forms. We're going to get into that in a series of videos and webinars about, hey, how you can use these forms. But in addition to that, something we're going to try this year that we haven't in the past, we're going to also provide, for a lack of a better term, scripts around maybe some of the new forms, like the RE5 prior to showing agreement, to give you and members an idea about maybe how you present this to a potential buyer who just called you and wanted to see that new property. Okay?
Question here.
Oh, okay. Yeah.
Okay, talking about the RE5.
RE5.
That's wonderful. Say you're at an open house, do you have everyone that comes through the open house signed up?
Oh, we're gonna talk about the open house in a minute. We have that specific, so if we can just put your question on hold, we do have someone to cover.
Sign call if you're a listing agent.
Yes, so there's been specific things with, so open houses and sign calls are considered a seller benefit, right? You're showing the house for the seller. So you do not have to show them with those forms because you're showing it for the seller. Now, if I get a call and to show Ophelia's listing, I have to do that form because I am showing it to the buyer. But if Ophelia gets a call for her listing, she's showing it for the seller. Does that make sense?
Yep.
And so you don't have to have a stack of these forms. You might want them in your car because you know how often you go back to your office before you go show a house, right? You're out in the car, but that's a totally different issue. Now I want to talk a little bit about compensation because David mentioned briefly the advertising of compensation. And when we were at NAR mid-year, they were like, you can advertise it on your Facebook page, you can advertise it on your signs, you can advertise, like they were like, you can advertise it anywhere but the MLS, and we'll have Kit talk about that in a second. But a week later, the Department of Justice sent a little shot over the bow and said, let's not do that. So I'm not sure where compensation, I'm gonna let Kit address compensation, and if you can delve into this piece or not, but where people could expect to advertise it since it's being taken out of the MLS completely.
Hi. I think that's the important phrase right there, is it's being removed completely from the MLS, meaning not only are our fields changing, meaning there's not going to be a place for you to put compensation, but you are not going to be able to put it in agent remarks. You cannot put anything in the description about the property. You cannot attempt to do Morse code in the MLS or put a photo of your listing with a hand held up with a certain number or 5. It can't be anywhere. And I think that is probably for all of us brokers, that's the hardest part to explain to our agents, is that we recognize that this has always been our tool, our number one tool to communicate between our parties, but we're gonna have to go back to texting and calling and emailing. Whoever asked the question about email, you asked about yes, you might have to, or maybe you save a screenshot of the new forms and you could text that to an agent if they reach out to you to show what compensation would be, but it's going to be critical not to put it anywhere in the MLS and to teach your agents that they cannot do it. However, on that note, here's the gray part of all of that we are still working through at the MLS. Can I talk a little bit about the enforcement piece? The enforcement piece is completely overwhelming for us at the moment. As I'm sure you all can imagine, your agents absolutely love to receive enforcement emails and calls from the MLS. And we are the last people in the world who want to try to police these forms being signed. However, we've been instructed that that is our role. So we are still working through the best way to do that without having to hire an entirely new staff member or 10 and attempt to do what it is that we have to do in a nice way. And so please have some grace and ask your agents to have some grace with us there, because we are working through how that's going to be done. What we're also trying to figure out right now, and where we all found when we were in DC there was a lot of gray area, is on this matter of past data and how concessions are being listed in the MLSs going forward, and what that does to the integrity of our data going forward and the tools that the appraisers need. And I would argue, and we did this in our board director or our executive committee meeting this week, but as an agent, when you're working on pricing property out for your sellers, it would be really nice to know what all was given away, right? Whatever that was, because you could have two homes priced $50,000 apart that look pretty similar at first glance, but are going to be different if there were concessions. And when I say concessions, I mean or anything that seller, the net price to the seller, right?
So we are in the process of talking to a lot of incredibly large MLSs across the nation that have all made some different decisions about what their process is going to be going forward to determine if we can figure out a way to provide data to. I would really love to see it, I'll tell you honestly. You know, the ability to look at that data long-term, but is that going to be potentially in conflict going forward? I'm talking about on closed listings, right? So not obviously anything that's active. But I would echo what Elizabeth said right now, which is the DOJ made a pretty strong statement a couple of weeks ago about where we are allowed to show offers of compensation. So I know personally for my own brokerage, I'm going to be encouraging my agents to go the old-fashioned way of phone, text, and email, and be careful until we see what they do. I mean, this could be, you know, we could just end up right back where we are with another lawsuit scenario if we just, yes, we did what we were supposed to do with the MLS, but now we've got it everywhere else, including on our signs and so forth, which can technically all be done. And a question in the back, Taylor, can you? Thank you.
Hi. So we are supposed to implement all of the new forms and changes come late January, early August, correct?
17th.
Okay.
August 17th.
And the final approval is not till November. So therefore, there's that time period in between when we implement and when the final approval happens. What are the chances that everyone implements this across the country and changes their ways of doing business, and then it's not approved, or it goes back into court to have changes, further changes because they don't like how we're doing business or how the gray area is being done?
We're gonna let our recovering attorney for IR tell us the answer to this.
Well, you cut me to the quick. Let's talk about who could come in the meantime and file an objection to the settlement. DOJ. What has DOJ said? They're not going to take a position on the settlement itself. You heard that from one of their attorneys in a different case. We can touch more on what DOJ's position could be in a minute. Who else could come in? It's a builder. We saw a builder out of Atlanta who has probably over 20,000 claims in the course of the Sitzer-Burnett settlement, complaining about the process, not necessarily the settlement, but the process of having to enter those individually. So you could have disruption to the settlement prior to the judge approving it in November. You're correct on the time frame. But I think the best indication of where the settlement's going is when the plaintiffs filed their motion for preliminary approval, the judge said he agreed. This is the judge who's been super critical of NAR, very critical of the brokerages involved in this litigation. He did not take issue with the terms of the settlement. He didn't take issue with the financial provisions of the settlement. So from that standpoint, we saw the other day a buyer who was not part of Sitzer-Burnett, which is sellers, right? A buyer is now appealing the settlement in Sitzer-Burnett. So I want to caution you to not get wrapped up in all the legal machinations between now and November. Because I would offer and submit to you the provisions we're talking about, the changes to the forms we're talking about, just to the forms, that's good for consumers. And it's going to help you be a better resource to the people you serve. Okay?
Yep, and our own attorney.
An important component, and I spoke about this earlier, is the settlement agreement is a contract. It is an agreement with the plaintiffs and the defendants in the lawsuit. But as we move forward in the changes to the to how brokerage will occur, we'll continue to have contracts, and those contracts won't be changing because of the the settlement agreement. So if you have a revised RE16B, whatever your agreement is for the sharing of a commission, if any, you will have a contractual relationship and the court won't be changing your contract. So moving forward, relying on the IR forms, that's going to be your protection from a contractual standpoint moving forward. What the court may do to change that, that's going to be changing the lawsuit, but it's not going to be changing your individual contracts.
Ken, when you were saying about removing all commissions from the MLS, are you alluding to past sales transactions? So we will not have any history of.
We don't know. That's what we're still trying to figure out right now. The hard part about this is that, and there's just stuff coming at us every day, even publicly, if you all follow some of the news, the large, news, real estate news organizations, a lot of the very large MLSs. And when I say large, like we're considered a regional MLS with, Glenn, how many members or subscribers we have right now? 8,000 or whatever. We're talking some that have like hundreds of thousands. And they are all sort of taking a slightly different opinion on what can and cannot be done anymore, outside of everyone agrees that we can no longer have an offer of compensation in the MLS. But when it comes to that past data, there's a lot of confusion. And I would say, as sitting in those meetings in DC, I think I was in 3 or 4 different MLS specific meetings in DC where the attorneys from NAR came in and were answering questions, especially during some of those roundtable type discussions. There were questions being fired at the attorneys. One question led to another question, which led to another question. And I think we all walked away saying we don't 100% have the answer just yet. So I know that in our executive committee this week, we've asked Glenn to reach out. If you guys don't know Glenn, he's our CEO of MLS. So I'm just a volunteer. So, but we've asked him to reach out to some of those organizations and find out the legal reasoning behind the past data, because that's what, that's what did someone do before. Because it also affects how we program the changes going forward, which obviously, just like your forms, has to be done in advance to ensure that the fields are gone. That's all technology, right? And every single one of these providers, we use Paragon here, but there's a handful of others, are all going to be working on making those changes nationally for everyone. So we're not 100% sure yet, but we talked as a group, and we'll talk with our board of directors here in a couple of weeks about really finding out the best way to continue to communicate what we're going to do with all of you in advance. Well, we do, but we don't. Yes, so if you read some of the stuff that's out there, it will actually show that the MLSs have until the middle of September in order to implement all of the changes. But in practice, I think we're going to follow the August 17th date. We'll hopefully follow it a little bit before, because I don't know if you all noticed, but the 17th is a Saturday.
So that August 17th date, just really quickly, when that date happens, those lawyers can send out postcards to anyone that's bought a house since 2016, 2014. 2014. So your agents' clients may get a postcard in the mail, and we're not supposed to give them advice.
Well, there's 2 things on that. First of all, there are already postcards circulating throughout Idaho. Okay, you've probably seen those. Those are the plaintiff's attorneys looking for plaintiffs who, part of the notice provision of a class action, they have to opt in. So they're trying to identify the class. So those postcards are okay. You've probably also seen through social media posts looking for potential plaintiffs. That's a whole different case. So, one follow-up to the question in the back about what's going to happen between now and November, I think the bigger disruption, and we just saw it, what happens when entities decide they're not going to opt into the settlement. You saw it with Northwest MLS. 37,000 subscribers, I think, and they're out of Washington. They are a non-realtor owned MLS. They said we're not going to opt into the settlement. So
We had a question back here.
So if we have a listing that's live July 15th, will we be doing an RE16B, or do we know yet, like, how that's gonna change in the MLS at that moment?
It's gonna hurt the brain. I believe that I read recently that if you are in contract prior to implementation, your contract and so forth, everything you have done up to that point is totally fine. But know that as of the August 17th date, if not a few days sooner, just for our sake, the compensation fields will be gone. So I think best practices is just to get everyone comfortable to start talking about it now with your, get your agents ready to start making the phone calls to the listing agents.
So Kit, my question is in reference to MLS and what they're thinking is, I've seen some MLSs offering a concession button. Is that, I have two questions, but that's my first.
Okay, so we actually already approved months ago prior to the settlement a concessions field button. It just hasn't been programmed yet by ICE, which is the overriding, it doesn't matter, you don't care. That change, we already actually had that put in place. I will say, so the board of directors for the IMLS has an appraiser on our board of directors, and they are concerned about this concessions portion being potentially utilized, which many MLSs are talking about doing in the future, because the definition says that a buyer's agent's commission could be considered or noted as a concession. What the appraisers have warned that when they're trying to give value to a property, if something is not like what did they call it? Like a normal customary, thank you, attorney, customary thing, then they actually have to remove that dollar amount from the value of the property. So, for all of us that have been practicing, you know that it has been customary for compensation to be included in the sales price up to, to this point where we're having these conversations. So I think that, yes, we will have the field, Tina. I think that we just don't know exactly what that field's gonna look like. I'm gonna use the Bright, is it okay? Is it okay if I talk about what Bright MLS is doing? Okay, so Bright MLS, which is I think they're the largest MLS out of the Washington, D.C. area. They announced this week, and you may have seen it in the news, that they are going to offer a concessions, this is on sold data only, when the property sells, a drop-down menu in which any concession, and there will be 4 choices as to what those concessions are, could be closing costs towards the loan, it could be, I forget all the different ones, like there were 4 options, and one of them was buyer agent commissions. And it's gonna be a drop-down menu. And so if you were closing out the transaction, you could put in exactly what concessions would have been placed. So obviously, like, that works great in new construction, it works great with lender rate buy downs, all that kind of stuff. And so now potentially it could have the buyer's agent's commission or any commission paid to the buyer agent in there. And we're trying to figure out, is that good? Is it not good? What should we do? Could we potentially utilize that model? Because I think for past data, that would be really helpful for us for trying to figure out how to properly price property. But does it open a can of worms? I think there's a whole lot of conversation, so we're working on that right now. Tina, do you have a second?
So my next question is I understand that the MLSs have to enforce. What exactly does that mean? Just taking the commissions out, but then we can throw it in concessions, so that's odd. But, or seeing that, what is the enforcement policy? What's that look like for us?
We don't have one yet. Yes, so right now, you'll notice that most enforcement happens upon complaints from other realtors. And so that's typically how, in the vast majority of things, we enforce. The other thing that you probably don't realize is that we have a program that automatically scans the data on a regular basis and shows potential violations, that might be happening in an MLS listing, and that can be a way of enforcement. We are talking with, again, other leaders around the country about maybe some of what their ideas are about enforcement, and to try to come up with the best practices for us that preferably doesn't include hiring more people, and also ensures that we are helping educate our community, because I think that's really what this comes down to is us, we as any of these organizations are here to educate our agents to have to practice, to follow best practices. And if we just we can't ignore it. We need to teach them, but I know I'm pushing hard, and this is just Kit Fitzgerald talking for the second, but I would really like to see some monitoring, but also some grace period, also some education period to make sure that you as brokers have an opportunity to really educate your folks first. And so that then by the time, if we will have rules, we will have fines, we will have all of that, because we have to show that we're following what we're being required to follow per the lawsuit, but we don't have it figured out yet.
So just real quick, since there are so many options for offering compensation, has there been any discussion as to maybe put a field in the MLS or allow us to use agent comments saying, in order to figure out what the compensation is, please use this app and go to this web address, call this agent, email this agent.
That'll be a
Is there
no.
some way to do that?
No, and no. We cannot have anything
So there's no way to
discussing
streamline
it, period. Zero. Yeah, just reach out to the listing agent is the best way to do it, yeah.
Realtors are very famous for loopholes. There's no loopholes here. We cannot find a loophole for putting commission on. So you can't have a picture with a percentage above the master bedroom bed. You can't have a plate of cookies. None of that stuff works. It's funny. And we're creative and we like to solve problems, but we can't do it that way. So please just encourage your people to know loopholes. I have one here and then we'll do Olivia.
Good morning. Thank you for being here. Is it permissible to just ask general questions now, or is there more education that you have for
I
us?
think we've answered most of the questions. And did we do more open house stuff or did we cover it? And you can add it. Yeah, you can add it to, Krista has a little piece at the end. So we're going to do general questions. I have one here, and then you back up here.
Thank you. I have two questions, mostly related to how we communicate with our clients and our customers. The first question I've been receiving is, how did we get to a place where it was common for sellers to offer buyer brokerage compensation? Our customers want that question answered. I know it's different from state to state, area to area.
I think Mike Gamblin might be able to answer this really well, but if you can, you're not on the panel, I know, but you're my brain trust. So it started a long time ago because we used to not have buyer representation, right? Buyer representation is fairly new. It's in the 90s. And so if you go back to the 70s, I think that's when maybe it. Yeah, so in the 70s and we saw someone in New Orleans. He talked a lot about this lawsuit and how it all came to fruition. And one of the things he talked about was that we've always just kept the same model. So even when we added buyer agents, we never broke the model to change the way compensation was done. And so that's part of what the DOJ, I think, has issue with. So the DOJ has a bunch of burrs in their saddle, and that's just one of them. Is that legal to say burrs in their saddle?
But if we're going to touch on DOJ, let's talk about a couple things with DOJ for a second. First of all of the litigation, DOJ's lawsuit against NAR was separate and apart. Okay? They were not involved in the Sitzer-Burnett, the seller side, or the buy side. So I want to go back to your question, which was, why is DOJ making you pay all this stuff back to such a prior date? DOJ's not. The plaintiff's attorneys convinced a jury that the policies of NAR and how they were implemented by brokerages across the country going back to 2014 violated the law. And then they convinced a jury to render a verdict of $5.6 billion against NAR and those brokerages. Now, there's a lot of people in this room who, like me, didn't understand why NAR settled this case. I woke up on March 15th and I was surprised because I had heard all along, we're going to fight this, we're going to keep fighting this, we're going to take this to the Supreme Court. There's a reality. Do you know how much the bond would have been in the court from the judge in order for NAR to appeal that case? Over $1 billion. Now, I don't know about you, NAR does not have over $1 billion to appeal that case. Now, on the flip side of that, settlement is not an acknowledgement or an admission of wrongdoing. They settled the case because they thought it was the most expedient way and most beneficial way for you, the membership, to move past this. And I would agree with them on this point. They settled all of the sell side cases, over dozens of cases from sellers across the country with this settlement. Okay, so you don't have to worry about Sitzer-Burnett. You don't have to worry about other sell side cases. By the way, you don't have to worry about the next seller coming in as long as you comply with the terms of the settlement. And they did not admit fault. Again, it was not an admission of fault. It was not an admission of guilt. It was simply saying, one, we think this is the best path forward for our members, and we have a fiduciary obligation to our members to do right.
So in relation to communication with our customers, they're not going to understand any of that. I was of the understanding that it had to do with creating competition in the market at one point. With listing brokerages said, hey, if you bring a buyer, this is what we're going to offer to that buyer brokerage. Is that in general the history of how it came to be that buyers brokerages were being offered compensation by a listing brokerage? Is it okay to say that one sentence and that our clients, I mean, is that an acceptable answer to
That's
that
as
question?
factual as any.
Okay, I just want to make sure I'm not, that we are not communicating to them that,
I think you have a bigger problem.
yeah.
I don't think that's going to be the question they ask. I think questions are going to revolve around, hey, I heard there was this settlement. Now I don't have to do X.
I
heard there was this settlement. What does that mean to me? I want to buy a home. Oh, and I heard there's some form. I've got to sign a form now. The conversations are going to revolve around the limited knowledge of what happened in the settlement and the resulting practice changes. So the focus is going to be on explaining to them how this is beneficial for them.
Thank you. I've had both questions, so I appreciate that, and I have had that second question as well. So when a buyer client asks us, I want you to only show me listings with a 3% or whatever the
No numbers.
whatever.
We can't have
Excuse me.
numbers, sorry.
Sorry, my apologies. A certain
We're doing
number.
algebra today.
This is a quote from a buyer. A certain number of compensation or amount of compensation. How do we respond to that?
I think nothing changes here, in that especially if you have a buyer representation agreement that demonstrates what your fee is, and you've explained to your potential buyers that some sellers may be offering that compensation, and here's how we get compensated, and if we cannot get it this way, we're gonna work to get it this way, et cetera, et cetera, et cetera.
And if that buyer specifically says, then I only want to see things that cover the cost of your fee, then that's fine. That's the buyer's decision. And this is, more importantly, the perfect opening to why you need to be able to really demonstrate to the seller why compensation might be incredibly valuable to them, that it might open the field. And I think if nothing else, we are encouraging competition. Realtors have always encouraged, as many people to, that's why we put it in the MLS in the first place, as many people to see your property as possible. And so, I mean.
That's a good take. It's a good take. Here's the practice point though, that, what's gonna happen is somewhere down the road, somebody's gonna accuse you of steering. And so I guess my advice to you, this and 450 will get you a cup of coffee at Starbucks, is you probably should have some email in the file from that buyer saying, hey, I get it, you explained it to me, that's wonderful, I understand how all this compensation stuff works, and I only want to see houses within this range because I understand I can't afford it if you don't, and I need that buyer or that seller, to pay my compensation. If you have something in the file, that's going to protect you. And my advice to you moving forward is we're going to get past this. Okay? We got past the Great Recession. We got past COVID. We're going to get past this. The next one's going to be steering. And they're going to say, we're all steering now. And so my advice is to think about when you're having that conversation, memorializing it some way so that you can prove to whomever at some point that, no, I didn't steer them there. That's what they wanted.
You could put that in other terms and conditions. The other part is NAR is paying for ABR right now, which is the accredited buyer representative, so that will help you. And I do think, we haven't really talked about this, but if you're at a listing appointment, it's a really great opportunity for you to explain to your seller what a buyer's agent does and why they want one. Because I don't like working both sides. It's too stressful. I have other things to do. I'm worried I'm gonna make a mistake. And if I have a buyer's agent on the other side, it's so much better. So really go to bat for those buyer's agents when you're presenting your listing agreement. Olivia.
I was just curious. I know we can't hide pictures and cookies and things like that on the MLS. Can we have a field that indicates there is an RE16B exists? Is that the same?
Yeah, no.
I guess
See, we're so creative.
So I want to encourage all of you to put this great energy, all of this energy and effort into picking up the phone and calling the listing broker.
Okay, we have one in the back. How are you? Hold on, we'll get you a mic.
Thank you for the great information. So right now, when a buyer purchases the property, the compensation is a closing expense that's fundable, lendable. If I negotiate a compensation directly with the buyer paying my brokerage, is that still a cost of sale that's going to be a lendable, fundable expense?
Well, if it's rolled into the purchase price, yes. If it is not separate, then that's just the.
And it has to still appraise.
And it has to appraise.
Where's Jessica? Is she here?
So if the list agent has their compensation and it's solely for them, and I'm negotiating my compensation with the buyer, that's going to be an out of settlement cost. It's not going to be fundable.
If it's not in the price.
That question has been asked. The Fannie Mae, Freddie Mac has not given direct guidance on it. I've been talking with other lenders, mortgage brokers to try to get a more direct answer to that. And the best information I have is it depends, the attorneys love that word, it depends. It depends on the program that the borrower is under and the amount that's being put down. So right now, we're anticipating, and as all of this continues to unfold, we'll get more information. But we anticipate that the selling agent's commission would be part of the concessions field and analyzed as such under the Fannie Mae Freddie Mac program. And therefore, it's going to have a percentage cap based on the amount that the buyer is putting down on the property. And if I'm recalling correctly, it was, if you had a 90-10 loan to value ratio, then your buyer concessions could be, was it 3%? And if it was a 80-20 loan to value, then the total buyer concessions could be 6%. And I think it was a 70-30. There's a spreadsheet being presented by Freddie Mac, Fannie Mae on that, viewing that as a overall concession, and then it'll be a lending program. Will that change in time? We'll see, but right now, that's the guidance that we're getting from Fannie Mae.
And then, so the last question for IR then is on that form, is there any disclaimer or disclosure on that particular situation where the buyer could be presented with a cash situation?
It's going to be in the RA21, and it's going to be, that's the offer made to the seller.
It's also in the RE14, the
The
buyer
RE.
representation agreement, that the buyer is agreeing to pay the fee.
Okay.
So I think we have it in both places.
All right, thank you.
So I want to just maybe say one thing that you're not thinking about, and that is if buyers can finance the costs of their representation, what stops DOJ from making the argument that now it can be completely divorced? Be careful. That advocacy point is something we really need to think through.
Can you better explain?
Yes, I mean, I won't be as cryptic this time. I was being cryptic for effect. If you've been paying attention to what DOJ has said, DOJ wants to completely divorce sellers or listing agents paying anything to a buyer representative. DOJ wants to completely break that. Sellers pay for seller representation, buyers pay for buyer representation. That's what DOJ is saying, okay? If you get to the point where buyers can now finance the cost of their representation, I think we've made the argument for DOJ.
Yeah.
So let's be careful as our advocacy efforts move forward, and let's be really thoughtful about that component. Because the initial response is yes, we want buyers to be able to lump in the cost of a realtor to their loan. We want that, right? That makes sense on the face of it. But I'm just cautioning us as we move through that conversation. Let's be smart.
I think we have time for one more.
I'm looking at the practical realities of being in practice and trying to take listings and make sales. So let me set that base. What I'm seeing here is that we're going to go out and get listings, and when we do, we're going to negotiate the commission with the seller as to what they will pay as a commission. I'm going to come back to the office and I'm going to put that on some list that's going to say new address ABC 123 ABC Street, commission to be, and I'll put a dollar amount or I'll put a percentage amount on that piece of paper. Then when the selling agent out there showing property wants to show that property but wants to know what the commission is, they'll call into our office and ask, and the secretary or whoever will tell them what the commission on that piece of property is being offered to the selling agent. Does that sound like where we're going? Is that a practical solution to what we're doing?
That is as practical as any of the other.
It could be something like that.
Okay.
You just have to be careful also that I've had people ask, well, I really liked working with Lisa last time, but I didn't really like working with Tim. So Lisa calls me and says, what's the commission that the seller's offering? And I'm like, oh, it's great to talk to you. Here it is. And Tim calls me, nope, nothing. Be very careful that practice doesn't happen because it's very bad.
Well, but it's not unethical. You can
Sure it is.
No, you
Yeah.
can have varied commissions
No.
that you offer in different companies. You can do that.
Signed by your client, maybe, like.
Let's start with how I think this is practically going to work, because I love practicality. You're going to sit down at your listing appointment and you're going to explain all of the things you do for that seller. In the course of that, you're going to ask your seller, are they willing to compensate a buyer rep, a selling rep, if they bring a buyer willing and able and closes on the transaction? And they're going to say, what the hell does that mean? And you're going to explain it to them. And then you're going to figure that out. It's going to be in the RE16, okay? Then you're going to figure out how you want to communicate that to potential selling agents. Great, we're going to give you 2 or 3 tools to do that. You may come up with some on your own. Wonderful. That's how it's going to work, okay? Now, there's going to be, and there's a provision within the settlement that talks about uniform, blanket, unilateral, right? And there's a prohibition against that. And what I want to go back to, and I want to be very careful how I answer your question so I don't cause confusion, right? You're going to work it out with your seller. You're going to communicate that to any potential selling agent, all right? If you're negotiating, you may negotiate with your seller and say, up to X%. Great. And then you're going to have a conversation with your seller about, hey, this person comes to the table. They should receive all of that compensation. They're working hard for that and they're doing a good job. Okay? The settlement didn't change any of this. The settlement didn't change how you have that conversation about compensation with yourself. Now you have to have it though before you make offers of compensation. Now, so the settlement also says, but the settlement says in your written agreement prior to touring a home, you're going to say, I'm not going to receive anything in excess of what I spell out here. You can amend the pre-show agreement. You can amend that with the subsequent RE15. You can amend that with the subsequent whatever rep agreement, so the RE12 or the RE15, compensation or rep agreement. So that pre-show agreement that I showed you, the RE5, that can be amended by another RE5, or it can be amended by a subsequent rep or compensation agreement. So if you find out, oh wow, more is being offered, the expectation is you go back to your buyer and you say, hey, on that property, more is being offered. We need to amend this so that it reflects that. So, I mean, they can be amended. They're contracts. They can be amended. NAR has said that.
I'm a listing agent, I'm receiving multiple offers on my list. No one is restricted, or none of this has restricted my sellers, my clients, from negotiating on these multiple offers in the way that they see fit. Is that right? Right.
So you're going to get an RE21, your seller's going to say, I don't like the following things about the RE21, do an addendum. Or counter offer or whatever, sorry. Yeah, change it. Change it. You're going to send it back and the buyer's going to say, great.
The hardest part of all of this is for all the people who aren't in the room today. And I think that as brokers, the best thing that we can do is demonstrate good behavior and attempt to help correct anything poor that we see going forward. And I know none of that changes from every day that we live all the time, but we do have a very large window of opportunity of a lot of problems that could get us back in hot water. And so, you know, anything you all can do to encourage other brokers that you know that weren't here today to pay attention to everything coming out, I think is really important.
Just my soapbox.
Okay, I think we're done with the panel part. So I want to give a great big thank you to all these panelists, Michelle, Kit, Krista, David, Tim. They gave up their mornings. Some of them rearranged their schedules to be here, and we really appreciate it. And Michelle, you are valued even though you only answered one question. we just needed you to see that it was more of an NAR thing than an IREC thing, so I think that's important. We have, Krista, are you doing another little spiel? I also really quickly want to take it, the staff put this together, and they've done a really great job, because I know some of you guys are slipping out, but Taylor and Miana and Lisa have worked really, really hard, and Cameron, on putting this all together. So when you see them, thank them. It takes a lot more effort and time than we sometimes think. So thank them.
Okay, so I got my NAR hat on right now, okay, Not Forms Committee, NAR, and I just wanted the opportunity, since there are so many brokers in the room, so thank you BRR for doing this, because I think it's important for us to broker kind of, number one, know each other and then be able to have some conversations. From an NAR perspective, we need to know what benefits are out there, because this is going to help us also keep peace in our offices with agents that want to jump ship. Okay, so there are a bunch of broker benefits. I am the Idaho representative of the Broker Engagement Committee at the NAR level. And my job is to educate brokers on what those benefits are and help you guys do your job better, so you can then train your people and there's peace in the world. So I'll be quick here. Some of this you guys already know, so it's a little redundant, but it's their presentation. The membership offers invaluable benefits. And again, we need to drive this home, especially in this current climate. We've got advocacy efforts, huge. The publications, the research, the training opportunities, all the resources at the national level that they offer. Marketing, technology, I mean, the list is so long. Even savings, you can get like a Dell computer, rent a car. You can travel. There's like a travel option too, and dental.
They have a list, NAR has a list, I think it's 174 benefits to your membership. It's an outstanding list. You can pick off things off of that list that would really make a real strong listing.
Yes, they do, that's for sure. So thank you for bringing that up. And it also helps with connections, people in your community and worldwide here. So the broker value prop, we're central to the transaction. We're out there teaching, we're members of MLSs, we are educating our agents, we're dealing with risk mitigation, and all those problems that are out there. So we're central to it. It starts with us, guys. It really, truly does. And it just trickles down to the rest of the agents that we work with. So the advocacy efforts are huge, and I hope you guys realize that NAR is there for you. Some issues that we face. We've got the proliferation of teams, the growing influence and power of agents, because there's, we feel like there's a pecking order sometimes. Agents' expectations, the training, both new and seasoned agents, and the challenges just around changes, number one, and less seasoned agents in the field. I know you guys all feel that. I know I do. The fast pace of technology, we're trying to keep up with that while we're making money and feeding our families, right? And the agent need for regular communication with us. And I know that's hard. I send emails out and they don't open them and read them sometimes. I know. I just want them to read the emails. It's important. I'm not the only one that experiences that, right? Okay, good. Thank you. So what does NAR do for brokers? We've got governance representation. I'm a voice right here, standing before you as an NAR representative, trying to show you that there's a lot more benefits out there for you. There's networking opportunities, there's the broker summits, the webinars that they do monthly. There's resources, which we kind of talked about, the financial wellness. Center for Financial Wellness is an awesome benefit that our agents can use, and it teaches them how to budget, and it offers them, how do I invest money that I'm making, those kinds of things. Something I don't want to be teaching agents, because I'm not good at that. I don't know all the investment side of things, so direct them there. The newsletters that come out, there's grants. So this is more for state and local associations that they can apply for grants to then put on broker summits and educate their membership. So it doesn't really work much on the broker level, but there's opportunity there. There's access, all the technology that they've provided us, savings, all the, fun trips you can take, automotive travel that I mentioned earlier. So you can articulate the difference being a realtor versus a non-realtor through the That's Who We Are campaign. I'm sure you guys know of that. It came out how many years ago? 5 kids? She's still here now. And social media graphics, they already have all that stuff out there for us. Understanding the economics of buying a home, we've got competition.realtor, another great resource to use, and we can direct consumers to that as well, so they can read about the benefits or maybe learn something more about it. Where am I directing this? Just new resources for new members. So they do have a new member orientation at the NAR level that you can ask your agents to participate in. I did that probably 3 months ago, and I even learned more about NAR than I knew, and I've been a member for lots of years. This is really a good one, the hot topics in broker risk reduction. There is a sheet that comes out every year of kind of the hot topics that we are facing as brokers. So I refer to that often, and it helps me to create topics for my sales meetings. So it's just another resource. And the Window to the Law, they're quick little video series. I'm sure you guys have seen some of those come through. It's neat to just kind of go through that and get some ideas and have somebody else telling your agent something, because sometimes, they don't listen to you. They feel like you're a broken record, like mom and dad. Getting a different perspective is kind of a good thing. The commitment to excellence endorsement. So there's a challenge that NAR has done, and I'm understanding that there's a new one coming out summer of this year. So this is an endorsement that will satisfy the Code of Ethics requirement, and it's kind of fun. They update it, and you kind of go down, a journey based on questions that you answer on what you know and don't know. And they might say, hey, go sit at a city council meeting, and then you check that box. So it gives you a bunch of tasks. It's actually pretty cool. So look out for that, and I don't know if you want to task your agents with that challenge. That'd be pretty cool. Broker dashboard access. So we've got NAR has their members first, which used to be their NERD system. So now it's M1, and now brokers have access to the information, which is pretty cool. I've been wanting that for years. So this can help us as brokers look at our agent list and see who's completed the Code of Ethics requirements. So then we can pick up the phone and say, hey, I see you haven't done it, and then we don't have to bother the local association. Do you have this and do you have that? Or look at the IREC education record and see if by chance they took it for CE for renewal, and then try to chase all that down. So it should be easier to then determine what your agents are doing. It also will share with you too, what committees they belong to, and kind of that experience, what designations they've got, things like that. So I think I saw a email come out just recently from NAR about the dashboard. So there's a webinar coming out. So as brokers, you probably have seen that too. If you did not and you want to get that information, just reach out to me and I'll send it to you. And there's more. Broker.realtor. We're brokers, we're realtors. They have a whole bunch of information for us. If you're not using it, not looking at that, please do. It can just help you. And that's all I had. Any questions?
I have a question.
Yes.
So, thinking ahead, I just see something down the road where there's gonna be more and more and more people looking to buy a house who are going to be doing so without being their own buyers. They're gonna go to Zillow. They're gonna say, oh, there's all that. Zillow's a member of IMLS. Look, these are all the houses for sale. They're gonna go right to the seller's broker. And just not have, somebody looking out for their own interests. I just see that happen. You have a comment on that?
Not as the NAR broker engagement representative of IMO, I do not. But I feel your pain. I see that happening too. And I think it just starts with education. I guess that's my comment. We just have to kind of start at the ground and educate, and express to the consumers how important representation is. Thank you.
The key for me, and I think Michelle will reinforce this, is to review your duties to a customer. And so you have, there's a list of duties to a customer out there as an agent. One is to facilitate the transaction. I'm forgetting the exact terms of it, but it's 54, 20, 86, 85, and 86 duties to a customer, duties to a client. And I'd encourage you to review that and say, okay, here are my responsibilities to a customer. And if you customer want to go this alone, you can. Here are my responsibilities, and anymore, this is where I'm drawing the line, and that's not part of my obligation to you.
Well, bottom line is, money talks, and if they can't afford to pay their own buyer's agent, and they can't wrap that into the loan, then they're gonna have no other choice but to go it alone, right? Because nobody wants to work for free.
That's absolutely been the arguments in the value of the cooperative compensation rule, absolutely. Value a realtor brings to any transaction.
I think there's also a worry that there might be bartering that happens too. I don't think anybody's thought of that particular issue, but what's to say you can't afford to pay me and you own a cabin in McCall and I get to use it for a month? How does my broker get paid? Like, that's a can of worms that you guys need to think about.
Don't give them any. So, on like the legal aspect of things, doesn't it offer the seller protection from possible future litigation for the buyer to have their own representation through the transaction?
Maybe the listing agent. I don't know if the seller is protected.
No, I mean, well, yeah, I mean, it would. I'm just thinking, because I mean, lawsuits happen, right? And if a lawsuit happens, the lawyer who's helping the person suing, if that was like the buyer, they basically sue everybody that was connected to the transaction, looking for who was liable for what damages, right? So buyers anyway. Well, I mean, you don't know ahead of time who's going to be that person.
I think when I'm teaching, I always tell you to call your attorney.
Well, yeah, but I mean, yeah.
I don't know the answer.
Yep. But the unfortunate part is people blame the broker, right? It's not my fault that I didn't investigate this house. It's your fault for not telling me to go do this. So having competent representation makes for a smoother transaction and should improve the quality of those transactions. And that's absolutely one of the points to make is you're selling your services is to the quality. But I see it all the time, folks calling me up and saying, it was my agent's fault. Read pull yourself up by your own bootstraps.
Okay, I promised to get you out of here by 11, so I'm going to hold questions. I want to thank David and Michelle and Krista and Kit, who's exited stage left. But thank you again. A big thank you to that forms committee. I know some of you are in the room. I don't know if you can fully appreciate how much time they spend on those things. It's a huge, huge undertaking, and they get no money, no compensation. They might get a donut, but they don't get a whole lot for it. And sometimes not even appreciation, because we grumble and complain sometimes. So thank you to all of you that do that. It's very appreciated by all of us. Those are a big value. And Chuck here thinks I should thank Tim again, so I'm gonna thank Tim because we really appreciated all of his guidance, and again to the staff. There are a lot of resources out there for buyers on NAR. They have all kinds of social media and guidelines. There's classes available, all kinds of things. So thank you guys for coming. There will be a feedback form I think Taylor's gonna send out. If you have questions, feedback, we could have done it better, you want to see more of these, whatever it is, we're here for you. So thank you for coming and have a great day. And it's National Donut Day, so have a donut before you leave.
Actually, I want to grab David real quick, and I won't leave, but I want to. Curious.